Hey everyone, and welcome to today's video. In this episode, we'll be looking at 3 sovereign citizens appearing in court, with the final case serving as a prelude to a video I've already covered. We'll begin in Kansas, where a sovereign citizen named Karen is granted a PR bond, only to immediately change the judge's mind. Then we'll move on to Michigan, where 2 judges make it clear that they are fully aware the sovereign citizen, before them views reality through a delusional lens, and they simply do not care. This will be my final video of 2025, so happy holiday.
All right, I think that takes care of the jail. The other one is appearing by Zoom remotely on her own. She was summoned to appear, and she has appeared on a summons. Michaela, it looks like we got you served in Wichita. It looks like there is a September battery charge, theft charge that got filed, and that's why you're notified to appear today. It's alleged that you had physical contact with Lori Jasso, Jasso. They call it done in a rude, insulting, or angry manner. So usually it's hitting, shoving, pushing, something of that nature, part of a fight or disagreement or out of anger. It is a B-person misdemeanor if convicted of battering someone. Maximum 6 months, $1,000 fine if convicted. And then it's also alleged that you took her purse and her cell phone and some stuff in her purse without her permission. The value less than $1,500, which also makes it a misdemeanor. It's a Class A non-person. It's always interesting that property crimes are a higher classification than person crimes, like a battery, but that's how it's set out legislatively. The maximum sentence is 1 year in the county jail and $2,500 fine if convicted. I'm going to enter a not guilty plea for you. If you're employed, I'm going to ask that you make an effort to retain your own attorney. If you're not employed and you have dependents that you support, then I will appoint an attorney to represent you. You will need to go before our magistrate judge on January 26th. The time depends on whether or not you get a court-appointed attorney or you hire your own. But the date's the same in front of Judge Webster. I'm going to allow you to sign your own bond since you were brought in on summons and you voluntarily appeared. You'll need to make arrangements to sign a $2,500 bond, which means if you don't show up for your court appearances, we can take a judgment of $2,500 against you, issue a warrant. It's added to your court costs in your case. And then probably a bondsman will have to get involved and you'll have a higher bond that'll be set for your future appearances. So that's kind of how a signature bond works.
A signature bond is essentially the same as an OR, or PR bond, meaning the defendant is allowed to remain out of jail while awaiting trial as the case moves through the legal process. However, this type of bond can be revoked at any time, especially when someone immediately goes on the record, ventures into La La Land, and says exactly what she says.
I am here as the representative of the entity that you speak of, but I'm the living woman and I do not consent to these proceedings. So, and also and for the record, I have the right I have the right to face my accuser, and they have to be a living man or woman. So, as far as that matter goes, therefore I move to dismiss the matter entirely.
Okay. Well, I move to order you to appear on Friday at 1:30 at the courthouse in front of myself, no matter what your name is or your affiliation. And to bring with you anyone that you are agent of or you represent. If you don't appear, I'll issue a warrant for your arrest or for her arrest.
Your Honor, are you setting the $2,500 OR bond?
No, I'm not.
Okay.
No, I've got to see her face to face and get her identifiers and have you personally appear, and that's going to need to be in person here at the courthouse in my courtroom.
What was the date and the time for that, ma'am?
Friday at 1:30, courtroom A in El Dorado at 201 West Pine. I think that makes that, the 14th at 1:30, please.
Okay.
Okay, I appreciate it. If there's
Thank
nothing
you.
further today, though, we'll adjourn on this case. We won't proceed any.
That has to be some kind of record for how quickly a PR bond was modified. Took her only about 3 sentences to lose the signature bond and prompt the court to require a more formal bond. Now we head to Michigan, where a sovereign citizen makes his first in custody appearance before Judge McNally, one of the toughest judges on the Michigan. It wasn't the grandkids playing with crayons, it was the slobbering nonsense that showed up immediately after he filed his motion. Alright, that wraps up the first hearing, but it's not the last time we'll be seeing him. As mentioned, he did have an appearance on July the 11th, though that one wasn't posted on YouTube. However, he appeared again more recently, about a month ago, before Judge Shackelford, and that hearing is available.
All right, this is the People versus Timothy Keynes. Mr. Keynes, if you can come on up, this is 230605, 230604, 230603, and 230602.
Good afternoon, Your Honor. James Gazicki on behalf of Mr. Kane. Mr. Kane is requesting a jury trial. And just for the record, I explained this to Mr. Kane that he's a sovereign citizen and I am not familiar, nor do I practice any laws regarding.
Because there aren't any laws regarding them, Mr. Gazicki.
Exactly, Your Honor. And I explained to him that I would represent him under the laws of the state of Michigan and obviously the United States.
All right, Mr. Kane, do you understand that? Is that a yes?
Yes.
Okay, so Mr. Gazicki has a law license and he's had it for a long time and he wants to keep it. So Mr. Gazicki is not going to come before this court or any court to make frivolous arguments or unfounded arguments on your behalf. But he has indicated that he would represent you on these cases, applying the law of the state of Michigan. You understand that? Is that a yes? Okay, she's taken down what you're saying and look the same. Okay, so all of these cases are from the same occurrence, is that correct?
Yes, Your Honor.
All right, so one jury trial date. On March 13th, we have Leroy Griffer.
That's good.
That's you? Will that day work? That's the only
Yeah, it'll work,
trial?
yeah.
All right. All right, so we will set a jury trial date for March 13th of 2026. You'll be required to appear in person that date. And the trial starts at 9 a.m., so you should be here no later than that, okay? And sir, one second. For any potential that I should set a final settlement
I would set a
conference?
final settlement conference, Your Honor.
Okay, so we'll set one final settlement conference. All right, that's your jury trial day. We'll send you out notice in the mail of your final settlement conference as well as your jury trial date, okay?
All right, thank you.
All right, you're all set.
That hearing was fairly uneventful, but I figured you'd want to see it anyway. Jury trials usually aren't streamed on YouTube, but if one does end up being posted, I'll make sure to bring it to you. Moving on to our next hearing, we have a sovereign citizen from Colorado, whom I recently covered. After watching that video, I went back through my older uploads to find the case they referenced, specifically the one where the judge ruled against his so-called right to travel argument, and I was finally able to track it down. If you haven't seen that video yet, there should be a card above my head linking you to it once this video ends. Well, your motion is denied. As the judge stated, I have no idea what a notice for record of impossibility to obtain a driver's license, registration, or insurance is, but it certainly sounds like, delusional reasoning aside, you are unable to obtain the requirements that legally allow someone to drive on public roadways. As a result, you should not be driving at all, regardless of whether you You may not have signed a formal contract, but the moment you chose to drive on public roadways, you entered into a social contract that comes with legal obligations.
So, sir, that is not a persuasive argument. As I've already mentioned, I am bound by the law of the state of
I'm asking a
Colorado.
question. I'm not making an argument, ma'am.
I am
I'm not
bound.
presenting an argument, ma'am. I ask a question. Please and thank you.
I'm sorry, sir, but your question is nonsensical. So I am already told you that it is that under Colorado case law and statute, you are required to
Can the
have.
state be an injured party, ma'am? Point of clarity, can the state be an injured party?
Yes. All right, so Mr.
It's a body politic, is it not?
Mr. Shadowlands, I am not going to engage in these sovereign arguments with you right now. What I will tell you is, if you wish, we're going to give you another court date. I guess you already you've bonded out on, I guess, 3 of the cases recently. I mean, we can set them all over to December 1st at 8:30 if you'd like. Is it your intention to apply for a public defender or hire private counsel, or do you intend to represent yourself in all of the cases?
Sweet jurist, I have no choice but to represent myself. I haven't received much response from the people. I can't seem to get my questions answered. I actually was not arguing, ma'am. I'm just asking questions. So at this point, I will waive the court, request an Article 3 trial, and discovery from the people, please, in all these matters. And we'll proceed by special appearance. Thank you.
Your Honor, if I may, these cases are not subject to Article 3 jurisdiction. I would,
Are not subject to what? I'm sorry.
Article 3 jurisdiction under the federal constitution.
He's talking about the federal constitution, I know.
Your Honor, my office has been in communication with Mr. Shadowins about the process for how to request and pick up discovery. We have also communicated, obviously, the WebEx information, which I believe he's utilizing to appear in court today. He is welcome to continue those conversations with the district attorney's office, specifically Investigator Schaff, who has reached out to him about the discovery process.
Okay, so you'll get your discovery. So do you want me to set your cases for trial, sir? Or do you want to make an effort to apply for a public defender or hire private counsel?
If the people are ready to proceed with trial,
Sir, I'm sure they will be whenever it's set, but it hasn't been set yet. So are you wanting to enter not guilty pleas on all cases? And I can give you what's called the Arguello advisement and give you jury trial and pretrial readiness dates. I guess I would recommend, Mr. Shadowins, that you talk with an attorney before you do that. But I guess, you do have the right to request that trial be set if you'd like.
thank you, Your Honor. I think it would be improper to plea at this point without said discussion.
So you're saying you don't know whether you're guilty until you see what the prosecution plans to use against you. In a drawer full of knives. This guy still isn't the sharpest wooden spoon. Next
Just give
voice.
you a pretrial conference on all your cases, and you should just follow the procedure that the district attorney's office has given you to get that discovery in these cases, okay?
I will do to the best of my impossibilities, clearly stated as a matter of record. And I would encourage the people and the court, please, to look at my filings. I was noticed by the court clerk that Your Honor was in possession of my filings. Again, I didn't get response from the courts or the people. And so I'm just here in good faith. However you wish to proceed, I waive the court at
Okay.
this time, Ms. Gilbert.
Well, so Mr. Shadowins, the only filing I have in, you submitted, bless you, a number of notices and other documents. They did not have a case number on them, so they appear just simply to be notices that you're of different things, but it certainly did not ask for any relief in those notices. They're all filed in 25T448, but because we didn't know what case it went to. I did notice that at least in some cases that you have filed a notice to dismiss or a motion to dismiss, and I have a difficult time reading your handwriting, so I couldn't address it over the weekend because I just could not read it on my computer. I am going to print them out in the hopes that I can decipher what exactly you're saying, and then I will address your motions to dismiss in writing. I'm perfectly happy to do that. But in the meantime, we are going to give you a pretrial conference date, and you should go to you should follow the procedures that the district attorney gave you in order to obtain discovery in all of your cases. All right, so that pretrial conference date is going to be December 1st at 8:30. December 1st at 8:30 on all your cases, okay?
That's a video I've already covered, and it's a great one, where the judge absolutely dismantles his arguments. The remainder of this hearing is simply the judge reading through the multiple cases against him. So I'm going to wrap things up here, and let you go check out that video instead. If any of these cases have follow-ups, and the last one definitely will, I'll be sure to bring those to you as soon as they're posted. Final thoughts. Happy holidays. If you enjoyed the video, hit the like button. If you didn't, hit dislike. Either way, don't forget to leave a comment, subscribe, and turn on notifications so you don't miss any future content. I'm Team Skeptic, and I'm out.